Time check was 8:45 a.m. Security had already beefed up at High Court Civil Division in Kampala as retired Count Dr. Kiiza Besigye and his lawyer Elon Kiiza appeared for the hearing of their application. They filed demanding for their immediate release. Dr. Kiiza Besigye, who appeared in court under tight security, looked frail, forcing the trial Judge Douglas Singiza to order prisons to take him back to prison, saying he cannot convene with a sick person. The court resumed after 10 minutes. Dr. Kiiza Besigye's legal team led by Elias Lukwago told court that the accused's detention without medical care infringed on his liberty and his constitutional rights.
For Dr. Besigye to regain his liberty, to be able to access a medical facility of his choice so that he can be thoroughly examined to assess his health situation and get proper or specialized treatment.
Lawyers added that there is no lawful warrant and any pending charges sanctioned by the DPP's office against Dr. Kiiza Besigye and Obed Lutale to appear in any civil court.
The Supreme Court did not say that those who are incarcerated should remain incarcerated.
The charges before the General Court Martial are not sanctioned by the DPP. So the charges to be taken or transferred to the civilian courts are those ones sanctioned by the DPP.
Basing their views on the decision of the Supreme Court, lawyers disagreed with the Attorney General's move of transferring the files to the DPP's office, alleging that this was misconceived by the Attorney General's office. With this, they asked court to immediately order the release of the accused.
Because the DPP cannot take over, the transfer order must be contextualized to mean, if you are interested, start a fresh complaint system.
The transfer is not on body. If there's any transfer or at all, is on file, not body.
Now that the Attorney General and the Commissioner General have not in any way attempted to justify the incarceration of Dr. Kiiza Besigye and Obed Lutale, my Lord, you be pleased to order for their unconditional release.
In reply, the Attorney General, represented by Johnson Natuhwera, maintained that the remand warrant that the Army Court issued against Dr. Kiiza Besigye and all other prisoners whose trials were before the General Court Martial have never been invalidated by the Supreme Court.
It only gave an order of transfer. The court ordered that all charges or ongoing criminal trials or pending trials before the court martial involving civilians must cease and be transferred.
Following the Supreme Court orders, the Office of the Attorney General, they are working tirelessly to implement the orders therein, in liaison with other relevant authorities.
I cannot mention how many files are involved, and the process of expediting the process is on course, and that's why the principal judge was allocated this responsibility. It's not in contention that the applicants were arrested and are in detention.
With various criminal offenses, including treason, my lord, which justifies their pre-trial detention under Ugandan law.
The applicants are aware that they are in detention legally, and the state is not denying where they are. And at any time you want to look at him, you can even visit him, anyone can visit him. And if anyone can want him to be produced in court, can be produced in court.
Since the whereabouts of the accused are known, the Attorney General's office says there is no need to have the habeas corpus hearing before this court.
Speedy trial and fair hearing is not one-sided. If the Supreme Court wanted to cancel the remand warrant, it wouldn't have taken a paragraph after almost 200 pages to mention so. There is nowhere where the Chief Justice said otherwise, apart from transfer. And in that so, it validated all the orders that all the suspects are based on to be in prison.
With this, they asked court to dismiss the application on grounds that it is misconceived and that the accused persons are legally detained.
Any argument about a warrant being not valid can only be made after the process of transfer has been completed. We pray that this application is dismissed for being premature.
And it's straight law, my lord, that any person who feels the application or the judgment of court cannot be construed in the way they feel it should. They applied the same court that issued it for clarification.
After listening to both sides' submissions, Judge Douglas Singiza will deliver the ruling on notice. Meanwhile, the same court has ordered parties in Elon Kiiza's case to file written submissions by close of business today. Speaking to the media after court, Dr. Kiiza Besigye's lawyers, including his wife and others, expressed disappointment.
Unfortunately, we have not got a decision today. We are walking away from the court premises without a remedy today.
Shame on him to send back to jail a man whose health is deteriorating very fast.
To stand with Dr. Kiiza Besigye and all political prisoners, exert pressure, because pressure is the only thing that works under dictatorial regimes.
Retired Colonel Dr. Kiiza Besigye is expected to appear before Buganda Road Magistrates Court tomorrow on another file concerning his health and personal liberty, coupled with his trial of inciting violence. Deborah Namamonde, Viola Nance Subuga, UBC News.